Today we're going to look at an overview of the Protection of Personal Information Act. We're going to cover the general application of the Act. We're going to look at who the role players are. We're going to look at the 8 processing conditions, which are the heart and lifeblood of the Act. We're going to touch on the prohibition of trans-border transfers of personal information. We're also going to consider the implications for direct marketing. What are the ramifications for non-compliance under the Act? The general application of the Act. First things first, POPI was signed into law by the President at the end of June 2020. It then came into effect on the 1st of July 2020, subject to a 12-month grace period. That means that all organizations have to be POPI compliant by 1 July 2021. POPI applies only when organizations process personal information which is entered into a record in South Africa. Processing and personal information are concepts we're going to look at in the next few moments. The first and foremost important question is what constitutes personal information? As you can see from the screen in front of you, personal information is anything relating to an identifiable person. Very importantly in the South African context is that identifiable person is not just a living natural person, but also is extended to mean any existing juristic person. This is unique to South Africa. Almost any identifying characteristics that you can think of will likely constitute personal information. That can include things like ID numbers, symbols, email addresses, views and opinions, race, gender, sex, pregnancy, personal preferences, educational history. Very importantly, is as a general rule, you do not need consent of the data subject to process personal information. But as you can see on the screen in front of you, there are 2 colors. There are black and red information. The red information is classified as special personal information. There are more categories of special personal information, which we'll deal with next. The black information rather, is information which is more generalized and can be processed without consent, but special personal information you require consent for. So special personal information, including the items on the previous slide in red, are also things like religious or philosophical beliefs, trade union memberships, health data, as well as information pertaining to alleged criminal behavior or criminal commissions by data subjects. As I've said a few moments ago, special personal information requires that you obtain the consent of the data subject prior to processing the personal information as a general rule. There are, however, some exceptions to this general rule. The most fundamental exception being where the processing of the personal information is required in terms of any law. For example, your BEE statistics, your COVID health information and the like must be processed in terms of legislation, and you would not need the consent of the data subject in order to process that. But it's very important when you come across special personal information that you first consider whether or not you have the consent of the necessary data subject in order to actually process that information. The next important concept is the processing of personal information. Processing is in essence almost any verb you can think of in relation to personal information. Not only does it include the transmitting or distribution, collection or receipt or collation of personal information, but even destroying, erasing, or restricting personal information can constitute processing of personal information. It is accordingly very important that you take a look at your historical records prior to 1 July 2021, as well as on an annual basis consider what historical records you keep, what purpose you keep them for, and whether or not they should be erased. If they are no longer relevant to the business and no longer required in terms of any law, generally they should be destroyed prior to POPI coming into effect in order to protect your company's interests. The Act recognises 4 key role players. The first most important role player is the data subject. In short, the data subject is the party to whom the information is about or relates to. You and I, in our personal capacities, are data subjects, but importantly, data subjects are very often employees of the business, as well as customers and suppliers and vendors and clients of a business as well. This is because POPI recognises juristic persons as being data subjects. The responsible party is the most important concept under the POPI Act. The responsible party, at its very nature, is the party who attracts and attributes all the liability and obligations under the Act. In essence, the responsible party is the party who determines the purpose of the processing of personal information. Your organization is a responsible party in relation to the information it holds. The responsible party must comply with the Act, it must comply with the 8 processing conditions, and it must appoint its information officer who will attract personal criminal liability for certain breaches of the POPI Act. But very importantly, the Act recognises that a responsible party cannot do everything itself. It therefore recognises the concept of an operator. An operator is a third party who does something on behalf of a responsible party. Very importantly, the operator is not regulated in terms of the POPI Act, save for 3 minor provisions that deal with the operator. The operator's only obligations are to immediately report security compromises, and there is an obligation on a responsible party to conclude an agreement with an operator in order to protect the security and safeguard the confidentiality and integrity of personal information being sent to an operator. Liability for the operator's actions falls squarely on the shoulders of a responsible party, and so it's very important that operator agreements are concluded, not just to be compliant with POPI, but also to ensure that you cater for liability and security safeguards. Finally, the regulator is the watchdog. It is the government agency that will be checking compliance in terms of legislation. It will be the organization that will be issuing the fines and penalties and conducting investigations into conduct of responsible parties and breaches of the POPI Act. The heart of POPI lies in its 8 processing conditions. Every time an organization, a responsible party, processes personal information, it must comply with 8 processing conditions. It is not sufficient to only say, yes, I have consent, and tick that box and move on. All 8 processing conditions must be complied with while personal information is being processed by your organization. The first processing condition is that of accountability. Importantly for accountability is that the responsible party must comply with this Act. It incurs the obligations and liabilities under the Act, and so it is accountable for breaches of this Act. Processing condition 2 is your processing limitation. POPI is there to protect the constitutional right of privacy. Our Constitution gives rights and remedies to juristic persons, and this is why the Act likely also includes juristic persons as being data subjects and whose personal information is protected. But very importantly, in giving effect to the rights of privacy under the Constitution, there is a limitation placed on responsible parties to only process personal information that is necessary for a specific purpose and does not unnecessarily infringe on privacy rights. That includes the principle of data minimization. It includes you using information, only that information that is strictly speaking necessary for the purpose for which you process it. You should not be using information beyond which is necessary for the purpose which you've identified. Processing condition 3 states that you must have a specified, legitimate and lawful purpose for processing personal information. That must also be defined and explained to data subjects. And so in any context which you process personal information, you must know precisely what that purpose is. It could be in the context of a contract. It could be in the context of a sale. It could be in the context of an employment relationship. But that would be your purpose, bearing in mind that you have to then be limited to that information which is necessary for that purpose. Processing condition 4, which is also closely linked to 2 and 3, prohibits you doing something else with personal information. So if I've defined a specific purpose for which I process personal information, I cannot now go and use that information for a completely unrelated and different purpose. That is constituted further processing, and further processing of personal information is prohibited unless it is compatible with the original purpose for which it was collected. So for example, if I am a shoe salesman and I must collect your address and your shoe size for the purposes of selling my product, I cannot now take your shoe size and send it or sell it to a health services company to determine whether or not you have a risk or probability of suffering a heart attack by virtue of the type of shoe and size of shoe you wear. That would be incompatible with the original purpose for which you collected that information. If, however, I required your telephone number in order to contact you about your delivery of your shoes, that would likely be compatible with the original purpose of processing. Or if I needed to use that information to send to a third-party delivery service, that would also likely be compatible with the original purpose for collecting. The fifth processing condition touches back on the concept of making sure records are looked at prior to the implementation of POPI. That is because a responsible party has the obligation to ensure that its records are complete, accurate, not misleading, and are up to date. It doesn't tell you how as an organization you must go about doing this, but it does say that you must ensure that your records are updated. This is particularly relevant for marketing companies, but it can be relevant for employment relationships, contracts, and the like. And so where you keep outdated historical information, you must put in place ways to either erase those portions of information that are not relevant for your purposes anymore, or mechanisms to constantly or regularly update your own records. That also boils down to the fact that you should only retain records for as long as you need it for the purpose or in terms of legislation that you are required to keep it for. You shouldn't keep records indefinitely. While you may have consent to do so, you are liable for the information, the quality of that information, and anything that may happen to that information while you process it, for as long as you keep it in your control. 6 and 8 are closely linked. While they are distinct concepts, it's best to deal with them in one. It is very important to know that you have to be open as a responsible party and transparent about what you do with people's personal information. What you will find on many websites is something called a privacy statement or a privacy policy. A privacy statement or privacy policy will dictate or tell the public or tell data subjects what it is you do with their information. This may also be found in a PIA manual, which you are required to have up and active on your website by the 1st of May 2021 in terms of the regulations under the POPI Act. It is very important that you are able to advise your data subjects as to what you do with their information. So while you may obtain consent, for example, to sell certain products and services to a data subject, you must also be able to tell the data subjects who you give that information to and what you do with it at any given point of time. And that is done generally through a privacy policy or privacy statement. Data subjects have certain rights, and that is where the 8th processing condition comes in. They have rights to access their information and records. So they are afforded with data subject access rights. They may ask you what information you have about them and what you do with that information. They may also ask you to update their information from time to time. And they may also ask you to erase or delete information where it is no longer necessary for the context in which it was collected. So where you retain, for example, a contractual relationship with someone, a right of erasure would not be absolute in all instances. But where you simply, for example, have a marketing relationship with a data subject, but you don't actually sell anything or require them to pay any price or the like, a right of erasure could be utilized in those instances. But where, for example, you have a home loan and you want the bank to forget about your home loan, necessarily the bank doesn't need to acquiesce and respond to your right of erasure because they have a right to retain that information. Finally, it's very important that you have to look after and safeguard the information that you keep in your possession. Importantly, POPIA doesn't only apply to electronic databases or electronic forms of personal information. It applies to any form of personal information entered into a record in South Africa, and that can include paper, filing systems, and the like. POPI doesn't prescribe what safeguards you need to put in place to protect the security, confidentiality, and integrity of personal information. But it does say that you must put in place reasonable technical and organizational safeguards to protect the personal information. There are many gold standards in a market that one can refer to for technical information, but organizational protections that should be in place can include things like clean desk policies, that you don't leave paper lying around, printer policies, that you make sure that you install passwords onto printers, that sensitive or personal information can't simply be printed and left on a printer for anyone to access. The way in which you store hard copy papers, all of those things can be considered from an organizational perspective to consider what safeguards you can put in place to protect personal information. And then we highly recommend that IT or information system audits are carried out on an annual or regular basis to consider what security safeguards you have in place. That can include implementing strong passwords and encryption services into your databases, to reconsidering and restricting access that certain people have to various databases or documents on your own computer systems. There are a number of things that can be done, and while the Act is not prescriptive, it is important to note that you are liable again for anything that goes wrong, and so it's very important to consider how it is you treat information and where the potential failings can come in from a security safeguards perspective. The Act also prohibits the transfer of personal information outside the borders of South Africa. This has very far-reaching implications for organizations who are engaged with cloud computing transactions, that are multinationals or have subsidiaries or holding companies that sit out of South Africa, who have clients or customers that sit out of South Africa. And so it's very important that you consider where in your organization do you process information out of South Africa? Do you transfer information out of South Africa? Any personal information? Even if you're emailing each other within South Africa, but your server sits outside of South Africa, that can constitute processing personal information outside of the borders of South Africa. So the first workaround that is that you have certain rules or binding agreements that you can put in place as a multinational organization in order to protect personal information and put in place adequate levels of protection. We don't yet have rulings from the regulator that deals with which countries constitute adequate levels of protection, or whether certain rules or agreements would constitute adequate protection. These are the so-called adequacy decisions that other regulators have put in place in other jurisdictions. This means that particularly where we're trying to rely on laws that we say are adequate for our purposes in other jurisdictions as a workaround, which is one other way of doing it, we cannot rely on juristic person information being adequately protected beyond the borders of South Africa, because we simply don't have laws outside of South Africa that give effect to juristic person information. Likewise, GDPR, which is a European-based data protection piece of legislation, it only gives effect to the protection of European citizens. That means that South African citizens' information, for example, that is processed in South Africa and transferred to Europe, would not necessarily receive adequate protection. And so we need the regulator to give us adequacy decisions in the near future to help answer this question. Finally, that means that for an organization, the most important and relevant thing it can do at this stage is obtain the consent of its data subjects to send information out of South Africa, both internally through its employee consent, as well as externally through data subject consent. The next important factor is to consider direct marketing. Direct marketing is not relevant to every organization, and so for the purposes of this training, I will briefly touch on the direct marketing provisions. The first important thing to note is that it is very important that data subjects, in terms of POPI, provide consent for the processing of their personal information, and that they are a customer of the responsible party. The aim of this is to put an end to cold calling and sales of historical databases. So we also need to bear in mind that information needs to be accurate, but it's so important that current existing consents are provided and received from data subjects. So where you participate in direct marketing actions, consent is the first and foremost thing that must be obtained. Otherwise, it must be your customer that you are marketing to where you don't have consent. Customer can include somebody that's provided or that's received a quotation from you. It doesn't mean you actually have to transact in terms of an exchange of money. But what we are likely going to see is that other forms of marketing may pop up or crop up after July to fix the gaps. So for example, telemarketers and where you get those pamphlet drops and the like, those wouldn't constitute being regulated by the directing marketing provisions of the POPIA Act. And those sorts of provisions required opt-out as opposed to opt-in consents. Briefly and very importantly, non-compliance attracts certain penalties under the Act. Very importantly, that any person is entitled to complain about your actions to the regulator. That means it doesn't have to only be an affected data subject. What we may find is that your competitors may run off to the regulator to complain about you. There are sanctions that can be imposed. On the criminal side, it can be up to 12 months to 10 years imprisonment for the information officer, or up to 10 million rand fines, or both. That means the fines and penalties can be quite severe for failing to follow through with enforcement proceedings issued by the regulator. In addition to that, affected data subjects are able to institute civil actions in the courts against you to recover damages. Importantly, a new concept of aggravated damages or some form of punitive damages is introduced by the Act, and this can mean that a court, on top of awarding actual losses, can also award some sort of punitive aggravated damages award. And very importantly, organizations are liable for the actions of their operators and employees in terms of strict liability provisions in the Act as well. So it's very important that you comply to prevent fines, penalties, and civil damages being awarded against your organization in due course. Finally, the last topic we're going to cover is data breaches, or better called security compromises. Now, very importantly, we tend to think of data breaches as being sophisticated cyber events, hacking and ransomware, interception and encryption of emails and servers. While all those things likely constitute security compromises under this Act, it can also be a lot simpler. It can be loss of files. It can be theft of unencrypted laptops. It can be sending an email to the wrong party with information on that shouldn't be sent to someone else. Simple actions can constitute security compromises or breaches in terms of the Act. So fundamentally, a breach or a security compromise under POPIA is where you reasonably suspect or actually know that personal information, remember how widely defined personal information was, has been accessed or acquired by any unauthorized person. Then you have what constitutes a security compromise. Now, very importantly, a security compromise triggers a mandatory notification obligation. Twofold. One, the information regulator must be notified as soon as reasonably possible of the security compromise. And the affected data subjects also have to be notified. So you can imagine the ramifications from a liability and reputational perspective. Not only do you perhaps open the door to an investigation by the regulator, but you also may open yourself up to civil liability by data subjects. And there's no work around this. You have to report breaches. It doesn't take into account any concept of potential harm to data subjects when considering whether or not to notify of the breach. The notification, while having a quick turnaround time of as soon as reasonably possible, is also a comprehensive notification. It must take into account things like what has gone wrong, what you've done to remedy it, what you believe the potential harm and ramifications can be. All these things need to be dealt with in a very short time span. And so it's very important that you have a robust incident response plan in place and that you regularly practice and dry run the incident response plan to ensure that it actually complies or meets the obligations that you want it to. You must have, in terms of that incident response plan, the appointment of an incident response team, a handful of people on the ground that are able to deal with this as reasonably and sensibly as possible in very tight timelines. I've also added some context to what a personal data breach can mean. It is not defined under POPIA. We have looked for the context of this to GDPR, and you can see it's things like destruction, loss, alteration of personal information. And it's very important to know that there are serious real-life implications for data breaches. And so reporting things properly and remedying things properly are very important to try and mitigate any losses. Thank you very much for the time, and please feel free to contact your information officer or training officer within your organization in order to deal with any questions or for further information.